This week, in a federal courtroom, U.S. Marshals physically removed the sitting president of the United States from the proceedings, not because of protesters outside, not because of a security threat, because the presiding judge determined that Donald Trump's conduct toward a witness had crossed a line that no court can tolerate. Before you dismiss this as media exaggeration or assume the worst based on a headline, I need you to look at what actually happened, not what pundits say happened, not what his lawyers claim happened, what the court record shows. I've sat through hundreds of federal trials in my career. I've seen defendants lose their composure. I've seen judges issue warnings. What I've almost never seen is a judge ordering marshals to remove a defendant mid-proceeding. That action tells you something went fundamentally wrong. Marshals don't escort you out because you rolled your eyes or sighed too loudly. They remove you when your presence threatens the integrity of the proceeding itself. So what did Trump actually say? What did he do that made this judge, a life-tenured federal judge with no political axe to grind, decide that the trial could not safely continue with him in the room? Let me show you the sequence based on court records and witness accounts now available, because once you see the timeline, you'll understand why this happened and you'll understand what happens next. Let me walk you through what occurred, because precision matters here. The proceeding began like any federal court session. Attorneys present, defendant seated at defense table, jury in the box. A witness took the stand. According to multiple accounts now confirmed by court observers, this witness was testifying about events directly relevant to the charges. Their testimony apparently contradicted statements Trump has made publicly. That's when the disruptions began. First, audible comments from the defense table. The judge issued a verbal warning. Standard procedure. She reminded all parties that courtroom decorum applies equally to everyone. But the comments continued. The judge called a sidebar with Trump's attorneys. She was direct. Control your client or there will be consequences. Moments later, the witness resumed testimony. And according to the court record, Trump turned toward the witness and made a statement. I want to be precise here. Accounts vary on the exact words, but multiple observers describe it as a direct comment aimed at the witness while they were testifying. The judge's response was immediate. She halted the proceeding. She stated for the record that the defendant's conduct constituted witness intimidation in open court. Then she said the words that will be studied in law schools for decades. Marshals, remove the defendant from my courtroom. Within 60 seconds, Trump was escorted out. The witness remained on the stand. The proceeding continued without him. Now, if this were the first time, you might call it an outburst, a bad day. But let me show you the pattern, because prosecutors don't look at isolated incidents. We look at behavior over time. May 2024, Trump's hush money trial in New York. Judge Juan Merchan threatened to remove Trump from the courtroom after repeated gag order violations targeting witnesses and court staff. Merchan told him directly, "I will not tolerate that." August 2023, Judge Tanya Chutkin in the January 6th case issued a gag order specifically because of Trump's public statements about potential witnesses. Her ruling cited the need to protect individuals from harassment and intimidation. December 2025, Jack Smith testified before Congress about Trump's conduct during the federal prosecutions. Under oath, Smith told lawmakers that Trump was making statements that were endangering witnesses, intimidating court staff, intimidating my staff. That's 3 different judges, 3 different courts, 3 different jurisdictions, same pattern of behavior. When I prosecuted organized crime cases, we called this consciousness of guilt. Someone who respects the process doesn't attack witnesses. Someone who fears the evidence does. You've watched this unfold for years. You've seen the warnings. You've wondered why nothing ever seemed to happen. This week, something happened. A federal judge enforced the rules that apply to every defendant in America. You've heard the term witness intimidation. Let me explain what it actually means in a federal courtroom, because this matters for understanding what comes next. Under federal law, witness intimidation isn't limited to explicit threats. It includes any conduct intended to influence, delay, or prevent testimony. The key word is intended, but courts also look at effect. If your conduct would reasonably cause a witness to fear for their safety or alter their testimony, that's enough. The law is designed to protect the integrity of proceedings, not just individual witnesses. Now, you might be thinking, can a judge really remove a sitting president from a courtroom? The answer is yes, Absolutely, yes. A courtroom is one of the few places in America where a president has no special immunity from the basic rules of conduct. The judge controls that room, not the defendant, not the defendant's lawyers, not the defendant's political supporters, the judge. That authority exists because justice depends on it. If witnesses can be intimidated in open court, testimony becomes worthless. If defendants can disrupt proceedings without consequence, trials become theater. What this judge did wasn't extraordinary. It was ordinary enforcement of rules that exist for everyone. The extraordinary part is that it had to happen to a president. So where does this lead the case? That's what I want you to understand next. Here's what's at stake now, and I want to be direct with you. This removal has immediate legal consequences and long-term implications that extend far beyond one courtroom. Immediately, the judge has options. She can hold Trump in contempt, she can impose sanctions, she can modify the conditions of his trial participation, potentially requiring him to watch proceedings via video link rather than sitting in the courtroom. She can also refer the conduct for separate criminal investigation. Witness intimidation, if charged and proven, carries serious penalties. None of those options require her to dismiss the case or grant him special treatment. The trial continues, but the implications go further. Judges across the country are watching how this situation is handled. Every federal judge who has ruled against this administration, who has faced threats and harassment as a result, is paying attention. If this judge's ruling stands, if the system supports her authority, it sends a message. Courtrooms remain places where the rule of law applies to everyone. If her ruling is undermined, overturned on appeal, or simply ignored by the executive branch, a different message is sent. I've prosecuted war criminals who showed more respect for courtroom procedure than what we witnessed this week. That's not hyperbole. That's my professional observation based on 30 years in federal courtrooms. The question now is whether the system responds as designed. Here's what I believe. I understand the frustration. You've watched powerful people evade accountability for years. You've seen delays, appeals, pardons, dismissals. You've wondered if the system is capable of functioning when the defendant has this much power. Let me tell you what I saw this week. I saw a federal judge faced with conduct that no courtroom can tolerate do exactly what judges have done for 200 years. They enforced the rules. They protected the witness. They removed the disruption. They continued the proceeding. That's not a political statement. That's the system functioning as designed. The defendant happens to be a former and current president. The rules don't change. The judge didn't invent new authority. She exercised authority that every federal judge possesses and has possessed since the founding of this republic. No one is above the law. You've heard that phrase so many times it might have lost meaning, but this week in a federal courtroom, a judge proved it still means something. The trial continues. The next hearing is scheduled. Evidence will be presented. A jury will deliberate. A verdict will be reached. That's not hope. That's not prediction. That's process. And the process works when people do their jobs. This week, a judge did her job.